The criminal law question from February of 2007 is one of those short, intimidating fact patterns. Take a look with me at the call of the question. You'll see we're talking about one criminal defendant in all four calls of the question. It couldn't get more straightforward and simple than this. 1. First-degree murder. 2. Second-degree murder. 3. Voluntary manslaughter. And 4. Insanity. Okay, well, the most challenging thing about this question is remembering all of the insanity defenses. So my first instinct in this, when I saw this question, was to make a quick little marginal note about irresistible impulse, model penal code, ALI, and McNaughton. And as it turns out, that's pretty much the hardest job we've got in this question, other than the typical rigorous analysis that's required by these very short fact patterns. Go with me to the top of the question, and let's have a look together. Paragraph 1 is all about the dispute that resulted in the death of the victim. Paragraph 2 is all about what happens at trial. Let's take a little more careful look at paragraph 1. The very first thing we learn about this defendant is that he's been mentally ill most of his life. He's working at a grocery store, and he gets into a dispute with the victim, who ends up dead. But read carefully, and we see that our defendant did not have any intent to kill this victim. However, he did intentionally strike the victim, and the victim then struck the tile floor and suffered a fatal head injury. Now the defendant is charged with murder in paragraph 2. We see that he has pleaded not guilty, and not guilty by reason of insanity. And that's reasonable enough. Look at what happens at trial. He takes the witness stand on his own behalf, and he testified that he has been provoked. Well, you can't say that the Committee of Bar Examiners is hiding the ball. We've got a provocation defense alleged by this defendant affirmatively. And then, read on. The fact pattern tells us that the defendant's testimony is that he could not stop himself from striking the victim. If you don't spot irresistible impulse when you read that, obviously you've got to be reading a little more carefully. And then finally we're told about the testimony of several witnesses, including a psychiatrist, who are on the stand to testify about the defendant's history of mental illness and his continued erratic behavior. And then we get the call of the question again. Well, whenever we get one of these short fact patterns, we've got to make sure that we do as rigorous a job as possible with regard to analysis. And when we're asked 4 questions, all about the same basic incident, it's also an opportunity for us to distinguish one body of law from another. And so you'll see as you review this answer that I have an unusually large amount of law in the answer. And I think it's necessary, because we're being asked to distinguish one charge from another, actually 3 different charges from one another. And as you'll see, I look at question 4 as applying to all of the other charges. So turn the page and have a look at the outline of issues that I've presented. You'll see that I don't really do anything out of the ordinary here. The Roman numerals all correspond to each of the 4 calls of the question. And then within each of these, I basically just go element by element. And you'll notice that I'm using the facts as headings. But within the analysis, I think it's very apparent as you get into the answer that not only do I find a home for the facts, actually, I find several homes for all of the facts this time around, but I also spend a fair amount of time explaining the differences between the various bodies of law. And when it comes to actually arriving at conclusions, my only firm conclusion is that the defendant can't be convicted of first-degree murder. I think it's possible this defendant could be convicted of second-degree murder or voluntary manslaughter. And I also think it's possible that he could be acquitted of all the charges based on a successfully proven insanity defense. So that's the basic structure of the answer. And that's how I'm thinking about the answer intellectually. Now let's spend a few minutes reviewing my model answer. I think you'll see that although there's plenty of room for reasonable people to disagree here and there around the margins, basically what I am doing here is presenting mainstream analysis in a pretty conventional way. So have a look at my answer to the first question about first-degree murder. You'll notice I'm not doing anything especially innovative here, and I'm definitely not doing anything different here than I did in the civil remedies subjects. You'll notice that I lead with the facts. I explain who the parties are and what happened to result in Dan facing these charges. Then I spend an entire paragraph going into a thorough definition of first-degree murder. This is a much more elaborate definition than you'll find in many of my model answers. And the reason for it is this question is so narrow. It's focusing our attention on all the different homicide crimes based on just 2 or 3 sentences of facts. And I think that requires us to explain the law a lot more fully than we'd be required to do if there were many different comparatively unrelated issues. Now you'll notice right up front that I almost lead with the conclusion at the end of the very first section. I explained that there are a number of different reasons why this defendant is not going to be convicted of first-degree murder. And you'll see that those reasons are all used as headings below. First, I indicate that the defendant did not intend to kill Vic. Secondly, I argue that this defendant did not premeditate or deliberate. And then, finally, I argue that this defendant did not commit an underlying felony. After all of that, then I spend a little bit of time focusing on the provocation defense. Now, as you'll see, I don't like this provocation defense very much. But with regard to first-degree murder, these facts are helpful to the defendant because even if we agree that the provocation wasn't reasonable, the facts do support a finding that the defendant did not premeditate or deliberate. And that would be potentially enough to defeat charges for first-degree murder. Next, I turn to my answer to the second question, second-degree murder. And here you'll notice that I lead with a much more concise definition, and I indicate up front that the prosecution's got a much, or at least a somewhat stronger case for second-degree murder than for first-degree murder. And you'll see that I follow the elements of second-degree murder. I discuss Dan's lack of intent to kill. Then I focus on malice. And here, I do think that there are facts that a prosecutor reasonably could argue to support a second-degree homicide charge. We have a defendant who shouts a threat, and he also uses what we could argue is a deadly weapon, his fist. And I think that's probably enough to establish malice, at least in the abstract. But when we took a broad look at what actually happened in this fact pattern, it isn't really a very good argument, because, for one thing, a fist isn't really a deadly weapon in the way that a knife or a handgun is. And also, I don't think that one punch thrown in a heated argument really is enough to establish malice. Then I turn to the provocation defense. And here again, I don't think it's a very good defense with regard to a justification of homicide. But I do think that these facts could be argued reasonably to vitiate the allegations of homicidal intent and malice. So by the time I reach a conclusion for the second question, I acknowledge that the prosecutor might win. But my conclusion is that the defendant properly would not be convicted of second-degree murder either out of these facts. Now I pause for a moment to acknowledge once again that reasonable people can differ. One could easily conclude that this defendant is guilty of second-degree murder. But I do think that one who reaches that conclusion would have to acknowledge that the defense does have a couple of pretty good arguments that might result in a contrary result, just as my answer acknowledges that the prosecution actually might win this case. Now we turn to consider voluntary manslaughter. And you'll notice, up front, I lead with a fairly complete definition of voluntary manslaughter as applied to the facts of this case. I think you can see right up front here, in my answer to question 3, that I'm trying to throw the grader that I understand where the law and the facts touch. Then I focus on the provocation, which I don't think very highly of in this context either, and then I focus on actual provocation. And here, that element is established. And we also can prove that the defendant didn't have time to calm down. So I conclude that a jury certainly could convict this defendant of this charge, really quite easily, unless they buy the insanity defense, which is the topic of the last part of the answer. So now let's turn to consider an analysis of the insanity defense as applied to Dan under these facts. And notice, again, right up front, I explain the legal context that an insanity defense will play in a criminal trial for homicide. So I indicate that this is something that the defendant must prove. This is a burden borne by the defendant. It is an affirmative defense. And then all I do is I go through the 4 different insanity defenses. And what I'm doing here is really not any more sophisticated. Actually, it's probably less sophisticated than what we're supposed to do on the multi-state bar exam. But it does show that there are certain aspects of the law that you just have to memorize, and this is one of them. So we focus on the irresistible impulse defense, and then the model penal code defense, M'Naughton, Durham, and then finally, I conclude that I think the jury is going to acquit this defendant based on the insanity defense. And so that's my final answer. But once again, I pause at the very end of this discussion to remind you that one could easily write an outstanding, compelling answer to this question that convicts this guy of second-degree murder and leaves everything else as sort of tertiary. To be honest with you, I don't think it's reasonable to convict this defendant of first-degree murder under the facts presented. However, just about any other answer to the rest of the question is easily defensible under the facts. And so, once again, the final lesson is, your job is to show the grader that you understand where the law and the facts touch, and the conclusion that you reach, whatever it is, has to be a reasonable one.